Good afternoon from Strasbourg, France, and welcome to the European Audiovisual Observatory webinar on Copyright and the Digital Services Act. This webinar is part of a series of regular appointments that the Observatory is organizing on a selection of topics concerning the so-called DSA package, the regulation proposals that were tabled by the European Commission last December. My name is Maja Capello. I am the head of Department for Legal Information at the European Audiovisual Observatory. Welcome, everyone. We have viewers not only from Europe, but just to mention a few, Mexico, India, Korea, Iran, Morocco, Ghana, Kazakhstan, Uruguay, Hong Kong. It's really from every corner of the world. So hello and welcome to all different time zones. The audience is most welcome to comment during the event. We have a chat box and a Q&A box on the right-hand side of your screen. And no reason to wait. Feel free to intervene at any time. Just to briefly introduce the topic, let me just mention and recall that the aim of the DSA is to modernize the current regulatory framework for digital services that operate in the European Union. And in particular, the Digital Services Act, which is one of the two legs of the DSA package, together with the Digital Markets Act, will introduce new measures to help counter illegal content online. And I would like to mention just a few set of tools so that we have a common vocabulary that will help us throughout the webinar. First of all, users will be equipped with a mechanism to flag illegal content, and platforms will be able to have particular cooperation mechanisms with the so-called trusted flaggers. There will also be rules on traceability of business users on online marketplaces, thanks to the so-called Know Your Business Customer principle. And the aim of this is to help detect the sale of illegal goods. Then, not least, there will be an update of the now 20-year-old e-commerce directive, setting down conditions for liability exemptions of online intermediaries, and also the attempt of harmonizing due diligence obligations for these players. And last thing I would like to mention is that the DSA also aims at helping member states with enforcement mechanisms, setting minimum standards for orders that should be applicable throughout Europe. Now, any kind of illegal content is at the in the scope of the DSA. This means also the unauthorized distribution of copyright-protected audiovisual content. That is why we have selected for the webinar of today the topic of the interplay between the DSA and copyright rules. And we will focus in particular on the copyright directive, the so-called directive on copyright in the digital single market, which has an approaching deadline for implementation, which is the 7th of June, basically next week. So even if many member states are still working on it, things are popping in and the transposition rules are coming. There are two last aspects I would like to flag just to complete the picture. There are still some elements that will have to be defined at European Union level, that is the guidelines on the application of a very important article of this copyright directive, namely Article 17. This article makes online content sharing platforms liable for the content that has been uploaded by their users on the platforms without the authorization of the rights holders. And the only way for the platforms to avoid a liability is to prove that they have made best efforts to obtain permissions from the right holders, and also that they have acted diligently in order to remove the infringement content and also to keep it unavailable. And at the end, just to make it even more complicated, this Article 17 is at the center of a case that is pending in front of the Court of Justice of the European Union. The conclusions of the Advocate Generals are expected for this July. So in the meantime, many transposition rules will have been adopted. So it will be very interesting to see how things will develop. So there is plenty of stuff out there. And this is the reason why we have called an expert to help us dive across these rules. And we have with us Eleonora Rosati. She is a professor of IP law and director of the Institute for Intellectual Property and Market Law at University of Stockholm. Welcome, Eleonora. Eleonora is also guest professor at the Center for Intellectual Property Studies, CEPI, at the University of Strasbourg, and associate of the Center for Intellectual Property and Information Law at the University of Cambridge. And I would also like to mention that last year, the World Intellectual Property Review listed Eleonora Rosati among its influential women in IP. So I think this is worth also mentioning, and we are very happy that you are here to help us understand these rules a bit better. We have asked you to give us an overview of risks and opportunities of the DSA in light of the copyright rules, and we look very much forward to listening to you. The screen is yours, Eleonora.
Thank you so much, Maya. Good afternoon, everyone. I would like, of course, to start by thanking the Observatory for inviting me and have the opportunity to contribute to today's discussion. I've prepared some slides for my presentation, so please let me share them. I think that you can see them fine. So the first question that one might need to answer and first of all raise is what relationship there is between copyright and the DSA. And the formal answer might be none, because if we read the text of the proposed regulation itself, it is explicit in saying in its Article 1 that the DSA will be without prejudice to EU rules in the field of copyright. And this might also mean the provision that Maya has already referred to, that is Article 17 of the DSM directive. This is a formally correct reading. In practice, this means that Article 17 will be, for instance, lex specialis, a special law to the general rules, the lex generalis found in DSA, and it will be applied in the specific sector of copyright, while the DSA will be relevant to any other type of illegal activities except those that, like copyright, will be regarded as lex specialis. So this is a formally correct representation, but as I will explain at the time at my disposal, it is substantially a rather superficial and misguided representation of the relationship that there is actually between Article 17 and the forthcoming DSA. Maya has already explained the history and content of this provision. Let me please add some further pieces to the puzzle. As Maya has recalled, this is a provision with a complex history. It was probably one of the most discussed provisions in the DSM directive. It came to be at the end of a lengthy debate, and the final text is indeed remarkably more complex than the initial proposal from the Commission. It is 10 paragraphs in length, and there are several aspects that were not present in the proposal and were introduced to address some of the concerns voiced during the legislative debate. There are also some aspects that still require clarification. Maya has referred to the upcoming guidance from the European Commission on the application of Article 17. There is also the pending judgment of the Court of Justice in the Polish challenge to the very existence of Article 17, or at least part thereof. And there is also the possibility that the Court of Justice tells us a bit more about the relationship between Article 17 and the pre-existing legislation, in particular Article 3 of the InfoSoc Directive, when it decides the YouTube case next month. This is, of course, a referral from Germany concerning the InfoSoc Directive, not the DSM Directive, but in his opinion last year, the Advocate General addressed this point, which also featured quite highly in the hearing that took place before the court. So, having said that, what is Article 17 all about? It is premised on a basic idea that certain internet actors, which the directive refers to as online content sharing service providers, do perform acts that copyright law restricts, and in particular acts of communication to the public. So as a follow-up to that, it is required for them to secure a license from relevant right holders to host and display content uploaded by their users. The license will cover the activities of the platform and of the users, at least to a certain extent. It is not required that a license is secured each and every time. There is, in fact, a special liability mechanism in the event that the online content sharing service provider has made the best efforts to secure a license and failed to do so. And the reason is that right holders are under no obligations to grant licenses, and it is a mechanism that shields them from liability, subject to fulfill a series of cumulative requirements, which revolve around the idea of a duty of assistance of the platform towards right holders and the implementation of a stay-down obligation at their end. There is also a special mechanism in place for certain actors, notably actors that are newer. They've been active in the EU for less than 2 years, and they have a turnover of less than 10 million euros per year and a number of unique monthly visitors that does not exceed 5 million. In addition to that, there is an important clarification in the final text of Article 17, that is that the hosting safe harbor, which is currently found in Article 14 of the Commerce Directive, shall not apply to them insofar as the activities covered by Article 17 are concerned. This does not exclude that the safe harbor might be successfully invoked in relation to other types of illegal activities. Just to give a concrete example, there might be a video content that is uploaded, and that content might be relevant both from the perspective of copyright, because it incorporates third-party content, and from the perspective, for instance, of defamation law, which in some countries is treated as a criminal tort and in others is not. So we have two different profiles. For the former, the online content sharing service provider will be ineligible for the safe harbor, and for the latter, in principle, it will be. There is also a reinstatement that the provision shall not entail a general monitoring obligation, and this is consistent with the provision that is currently found in Article 15 of the Commerce Directive. There are also specific provisions in place within Article 17 to safeguard users. Member states are required to implement in their laws a number of exceptions and limitations which are already found in the EU acquis, and there is currently an important discussion regarding the compatibility of ex-ante blocking initiatives with the safeguard of user rights. And the question of when the complaint and redress mechanism comes in the picture is also currently the object of discussion within some member states' transposition processes. So, as you can appreciate, it is an extremely complex provision, and looking at this formalistic reading that I've offered, it is something that qualifies as lex specialis to the DSA. Yet, the history of the DSM directive and that of the DSA is closely intertwined, and as I will explain a moment, there are several provisions in the DSA that are of relevance to the very application and the scope of application of Article 17. So if we look at the history, this slide summarizes some of the main steps in this shared history. It starts with the adoption of the Commerce Directive, which of course the DSA, as Maya has mentioned, intends to update and complement. And there is also in Article 17 a specific reference to the Commerce Directive. So this part of the history is a shared one. The InfoSoc Directive, which Article 17 to some extent is presented as an implementation and update thereof, was adopted the year after. And then if you fast forward to 2015, that is when the DSM strategy was unveiled, we begin a period in which copyright rules and the rules that are enshrined in the DSA are very close to each other. In fact, in the period between the unveiling of the DSM strategy and the adoption of the DSM directive, we have a 4-year window in which the Commission not only did propose the text of the DSM directive, but also looked at how to tackle illegal content online. There was a communication in 2017, a recommendation in 2018, and as you will know, these are relevant to the understanding of how the DSA proposal came to be. So it is an history that cannot be regarded as a separate one. It is closely connected. And indeed, in the DSA, there is a lot regarding the application of Article 17. First of all, there are indications that will serve to understand when Article 17 does apply in the first place. The DSM directive says nothing about the conditions at which an online content sharing service provider will be targeted by Article 17. Nothing is said regarding a requirement of establishment in the EU, or instead a simple targeting to EU-based users. The DSA instead adopts a targeting approach, and this is something that might be also relevant in the context of determining when Article 17 does apply. The Court of Justice of the EU has not yet endorsed a targeting approach in relation to the right of communication to the public, so it is likely that when there will be a question of application of Article 17, the rules in the DSA will be of assistance in this respect. There are also provisions that concern the calculation method to determine the number of unique monthly visitors. This is something that is found in the DSA and will be also relevant to the application of Article 17 because, as I've mentioned, there is a softer liability regime in place for certain types of platforms, and it is a system that is premised also on the number of unique monthly visitors to the services offered by that player. Then there are parts of the DSA that are relevant to the very application of Article 17 and potentially also elements of mismatch between the two. So, as I've mentioned, Article 17 provides for a system in which there is the possibility to escape liability in case no license is in place. It is a system that is built on an idea of a notice and stay down kind of obligation. The provision in Article 17 does not say much about the content of the notice that right holders will be required to submit, and one might think that guidance will be found in the case law of the Court of Justice of the European Union. The leading case 10 years later remains the decision in L'Oréal and eBay. It is also interesting that the DSA is presented as a codification of CJU case law when in fact, goes beyond that case law by providing that, for instance, notices will need to contain an indication of the URL at which the illegal content can be found. This is not something that comes from CJU case law, it is something else, and I'm aware that it has the potential to present a number of shortcomings when it is applied in the context of app-based illegal activities. So this approach in the DSA to clarify what a notice should contain might be also relevant to the very application of Article 17. In addition to that, the DSA provides a regulation of a trusted flaggers system. For certain commentators, a trusted flagger system will be also necessary to make Article 17 workable in the first place. And so here we have again a clear idea that these two instruments are in fact very close. And then there are aspects of the DSA that will be relevant to determine the scope of application of Article 17. And here we have an example of when the lex specialis character of Article 17 might come into consideration. Currently, the DSA is premised on an idea of notice and action, while Article 17 has a core intention of notice and stay down obligation. So here we have clearly an Article 17 prevalence and preference over the system envisaged in the proposal for the DSA. And then there are key aspects that concern safe harbor availability that will be relevant to the very application of Article 17. The DSA is interesting because it translates and transfers the provisions in Articles 12 to 14 of the Commerce Directive in its text. It says, on the one hand, that the safe harbors are available only to intermediaries, but then it also says that it is something that is available in respect of any type of liabilities. And it is clear that when we have a situation like the one that I've described of content that might be relevant from both a copyright and defamation standpoint, it is clear that, again, we will have a close connection between Article 17 and the Digital Service Act. Finally, there is something to be said about the Good Samaritan approach endorsed by the Digital Services Act. It is something that is a bit different from the US approach, and it is not something that is entirely foreign to EU law either. The Court of Justice itself has endorsed certain proactive behaviors on the side of internet actors. It has clarified that filtering obligations of a non-general kind are allowed under EU law. And we have also indications at the level of national case law that proactive behaviors might be not just legally allowed, but also economically recommended. And in this sense, we have an express indication in the decision of the High Court of England and Wales in Cartier, the first UK website blocking injunction in a trademark case, in which Mr. Justice Arnold, as it then was, did indeed make this statement. So, in conclusion, there is a lot in the DSA that will be both a joy and a wonder for the application of Article 17, and it will be very important, if not vital, for anyone working or having to do with copyright law to indeed be aware and closely follow the developments of this upcoming piece of EU legislation. And with that, I conclude and thank you for your attention.
This was really a guided tour across two important pieces of legislation, and it is very complex. So thank you very much for your help to read the different rules. We will come back to you later on, so now you can relax and listen and enjoy, because we will add another piece of a layer of information now, because of course the DSA package is a proposal from the European Commission. So who is best placed to tell us about the behind the scenes? The European Commission itself. And I'm very pleased to welcome today with us Marco Giorello. He's head of the copyright unit at DG Connect. And if he is now brought onto the screen, hello, welcome, Marco. I would like to tell our viewers that you are a lawyer by training, and you've worked for the European Commission now for more than 15 years, and you're covering numerous areas of the European internal market policy. Marco has been directly involved in the planning and the negotiations of the copyright reform, including the directive that we have now heard about from Eleonora. So, Marco, as I mentioned in the opening, and now also Eleonora Rosati stressed, the DSA has certainly different points of contact with the current regulatory tools while remaining a horizontal piece of legislation. What kind of interplay do you see now on the eve of the deadline for the transposition of this directive for the member states? The screen is yours, Marco.
So thanks a lot, and I'm very happy to be here today, not only to explain you let's say the Commission perspective on the interaction between the DSA and copyright, but also to listen to the discussion, and I am sure that this will be very useful also for us. I don't think I need to present the DSA in general, because I understand that this webinar has been preceded by other webinars where certainly you have already discussed the DSA by and large. I will just start by stressing again that the DSA is an instrument which has a horizontal nature. So from the Commission perspective, the DSA does not intend to be a copyright-specific regulation. It is a broad instrument which regulates a number of important aspects of the internet economy. It is to some extent also a modernization of the e-commerce directive. So for sure, there are interactions with copyright, but only as long as this horizontal rule may apply in some instances to copyright protected content. But I think it is very important, first of all, to stress that the objective of the DSA is not, from our perspective, to be a copyright specific regulation. This is expressed clearly in the DSA text itself, in Article 1 and also in Recital 11, which are without prejudice clauses. So these are clauses which make it clear that nothing in the DSA should affect the application of European Union copyright laws. And of course, this is relevant in particular for Article 17 of the new DSM directive, which has been explained in quite a lot of details by Eleonora. And this also, let's say, reflects the political intention of the European Commission not to reopen the copyright directive and to avoid putting into question everything which has been achieved through the copyright reform during the previous legislative cycle. And I think this is very important to stress because although, of course, there may be some interaction between Article 17 and the DSA and between more broadly copyright and the DSA, but I think that it is very important to read the without prejudice clause, keeping in mind that this is not only, let's say, a legal clause, but it is very much coming from the political intention, which is not to reopen the copyright directive through the DSA negotiation. And this is because, in a way, we had a very extensive discussion during the copyright negotiations, which have led to really a sort of lex specialis rule, which is very specific to all the check and balances that are required in the copyright system between right holders, platforms, and users. And we think that the balance that has been found there should not be reopened in the DSA. This means more in detail that everything which is within the scope of Article 17 should be left untouched by the DSA rules. So this is relevant, first of all, for the liability conditions, for the conditions of liability of the platforms when they deal with copyright protected content, which are defined in the way that Eleonora has explained by Article 17, and therefore in the same way as they are currently not anymore covered by the Commerce Directive, they will not be covered anymore by the DSA once this is adopted. But also the specific rules on notice and action in the DSA shall not apply to the situations covered by Article 17, because Article 17 has a specific regime of notice and action, which in the case of Article 17 is a notice and stay down, which then goes more, let's say, specific than the DSA itself. There are, on the other hand, I mean, some rules which are outside the perimeter of Article 17, which we believe would still be relevant also in the case of online platforms, because they are not specifically regulated by Article 17. One is the provision on trusted flagger. Other rules may be the rules, for example, on transparencies and abuses of notices, which are issues which are not specifically regulated by Article 17. They are, as I said, outside its perimeter and therefore may still be applicable. But of course, copyright goes beyond Article 17. This is a very important provision which, as I said, is left untouched by the DSA, but does not occupy completely the ground of all possible uses of copyright-protected content in the Internet. Notably because there are other type of intermediary services which may also interact in the course of their activity with copyright. In particular, platforms which are not covered by Article 17, but this is a rather limited, let's say, range of players because the application of Article 17 is rather broad, but not all platforms are covered by Article 17. But also, and more relevantly, other non-platform hosting service providers, which may play a role in the fight against piracy. So the provisions of the DSA, which may in practice have an impact actually on the functioning of the copyright system, are rather those provisions which may interact with the role of certain intermediaries as regards pirated activity. And for example, this applies to Article 8 of the DSA, which relates to court's orders. There is, of course, a certain level of harmonization of injunctions and court orders in European copyright law, in particular in IPRED, in the Directive on IPR infringements. But on top of that, Article 8 may still have a residual impact. And then, very importantly, the Good Samaritan clause in Article 6 and the notice and action regime will be applicable to hosting service providers which are not covered by Article 17 in an horizontal way, and then they would also apply in practice to notice and action in the area of copyright. So I think that overall the discussion about copyright and DSA is not much and should not be much a discussion about Article 17 and the new copyright directive, because as I said, the intention and also the Commission proposal makes sure that the copyright directive is left untouched by the DSA, but is rather a discussion about how the horizontal rules in the DSA may interact with the national rules and practices mainly concerning piracy and the role of intermediaries other than platforms. And I conclude by saying that we are seeing a beginning of a debate about the relationship between horizontal rules in the DSA and possible more specific, at least request to intervene in the area of piracy, as a result of a very important report which the European Parliament has adopted only a few days ago, which mainly deals with the piracy of sport events, where the European Parliament suggested the Commission to intervene to strengthen the fight against the piracy of sport content in areas which are somehow overlapping with the DSA, but not dealt with specifically in the DSA, like, the specific rules on trusted flagger and on notice and action. So I think that the debate ahead will be for piracy very much a double debate. So one is how the horizontal rules in the DSA interact with the fight against piracy, but second, and very much whether more specific rules may be needed to have a more specific response to the needs of the creative sector when it comes to illegal content online. So I would stop here for now, and I'm really looking forward to participate to the discussion, to listen to the feedback, and maybe if Maya wishes, I can still say some words at the end of the event.
Thank you very much, Marco. I knew you were the right person to ask because we have learned many things already. We have learned that you're basically working also already on something further in the field of piracy. This is, I guess you will have now a busy time working on the response to the European Parliament. And I think it was also very useful that you stressed indeed the fact that the interplay has to consider the scope and the horizontal issue, so that it's not necessarily two areas that overlap entirely, but there are some aspects of the DSA that might touch upon the DSM directive, which remains on its own path. So with this clarification, which I think was very helpful, I think we have now a good layer of information, and I will certainly take advantage of your offer to step in towards the end. So now you can enjoy the panel with the stakeholders, which I will now introduce. We have today with us four very important representatives from different branches of the audiovisual sector. We have Stan McCoy. He is President and Managing Director EMEA of the Motion Picture Association, MPA. Welcome, Stan. We have also Marco Pancini, Government Affairs and Public Policy Director for Europe at YouTube. Welcome, Marco. And then we have Stéphanie Martin. She is a legal advisor at the Society of Audiovisual Authors, SAA. Welcome, Stéphanie. And then we have also Maria Michalis from the European Alliance of Listeners and Viewers Associations, Euralva. Welcome to you as well, Maria. Very pleased to have you all with us. I will start with Stan. And just add that you're holding this post of President and Managing Director for the region encompassing Europe, Middle East and Africa of the MPA now for quite a while. You joined MPA in 2014 following a decade of government service, because you served as Assistant U.S. Trade Representative for Intellectual Property and Innovation in the Office of the U.S. Trade Representative. So if there is something you know in and out, is indeed copyright for the creative industries. And I'm sure that you have observed with the same concern as many that illegal activities concerning access to films and audiovisual content has not decreased in recent years. On the contrary, it seems that during COVID-19 outbreak there has been more piracy. And a stated goal of the DSA is, as we have heard, to reduce consumer exposure to illegal content. So how do you see this work in practice, Stan, from your viewpoint from the creative sector? The screen is yours.
Well, thank you. Thank you very much, Maya, and I'm really delighted to be here and delighted to have been invited. Let me just share my screen and show you a small presentation. And indeed, the first thing I have to say is that the views in this presentation do not belong to Stan McCoy. If you saw that moment of static there, that was Stan's feed being hacked by me, his evil twin, Dan McCrook, Cybercriminal. You can see my contact details there on my business card. And in replacement for whatever boring presentation Stan was going to give you about the DSA, I am going to offer you today a Cybercriminals guide to the Digital Services Act. I have to say, when Cybercriminals first heard about the Digital Services Act, we were quite worried. Indeed, as you said, Maya, the Digital Services Act sort of rhetoric, the philosophical basis behind it was grounded in less exposure to illegal content, level playing field against providers of illegal content. I mean, really a head-on assault on the cybercrime business model, something very troubling for all of us honest cybercriminals. I was initially most concerned about some provisions that Marco mentioned, some language that seems to encourage platforms to take voluntary measures against illegal content. Article 6 saying you don't become ineligible for exemptions from liability solely because you take action against illegal content. then I realized that language is really nothing new. If you go back to the 2017 communication, the Commission already told us that taking voluntary proactive measures doesn't automatically lead to online platforms losing the benefit of the liability exemptions. So that doesn't really change much, and as far as I'm concerned, status quo is good news for the cybercrime world. We're doing just fine under that rule. So then I started to worry that the real threat to cybercrime here might be in these due diligence obligations. They might oblige intermediaries to interfere with illegal activities, report on illegal activities, be more transparent. But actually, as I dig into it, I see some good points in the text. First of all, liability exemptions are not conditioned on compliance with the due diligence rules. What does that mean in practice? It means the platform doesn't have to earn the liability exemption. They just get the liability exemption regardless of whether they do a good job of complying with the due diligence rules. That's good news, I think, for all of us who want the platforms to not do a good job of complying with those due diligence rules. That by all means, don't give them any extra incentive, don't tie it to their own liability, just make it a kind of a regulatory requirement that they can shrug off, and maybe they'll pay a fine after a big court proceeding. Yeah, that's much better from the cyber criminal perspective. So big thumbs up on that one. Second point relates to these terrible know your business customer obligations. This is potentially the scourge of cybercrime in the DSA. I really have to say, from the standpoint of a practicing cyber criminal, it would be an incredible headache if we were being asked to provide true contact information and verifiable contact information every time we sign up for web hosting or domain names or other kinds of basic business services. So the good news here is that these KYBC obligations are limited to e-commerce marketplaces only. A big relief. So that's a piece of good news for cyber criminals everywhere. I would appreciate if you would not go to www.kybc.eu to learn more about that issue. The third great point, no stay down. So here we are revisiting after a couple of decades the whole notice. Would have potentially been an opportunity to look at the issue of stay down and provide a more durable regime than the constant treadmill of the notice and action. But fortunately, that's not the case. There's also that nice little URL loophole that Eleonora pointed out earlier. I do a lot of my cybercrime now through app-based technologies that don't even use URL technology. So that's good news. So basically, the DSA proposes process changes around notice and action, but no stay down, and therefore, happily, from my perspective, no real disruption of the current cybercrime business model. We're well adapted to notice and action. There are actually thousands of software scripts available for free on the internet that will re-upload your illegal content immediately, if it ever should happen to get taken down from your favorite pirate cyber locker. So good news for us to have minimal change on that front. Another cybercrime friendly provision, it looks pretty difficult to me looking at this proposal to kick a platform out of the liability exemption because of illegal activity. If you take a look at this language, it says that providers of intermediary services that deliberately collaborate with recipients to do illegal things don't get the benefit of the liability exemption. Well, good luck seeing inside the mind of the platform operator and proving deliberate collaboration. I think that's likely to help my platform of friends avoid liability, even if it can be shown that their service is objectively designed to favor illegal content. So if you're me and you want the service to be designed in a way favorable to illegal content, that is a good little clarification to have. So in summary, looking at this from the cyber criminal perspective, the DSA proposal fortunately doesn't live up to the promise of curbing illegal content. The ability of platforms to take proactive measures was already there back in 2017. The due diligence requirements aren't tied to liability, so they're more easily shrugged off in terms of compliance. The KYBC is limited to marketplaces only. There's no stay-down requirement, and platforms can still access the liability exemptions and might even benefit from this deliberate collaboration interpretation. All of that has to be a big relief to those of us in the cybercriminal community who want to keep on practicing the business model that we've been practicing for a good couple of decades now. But my last request to all of you would be, please keep this very quiet. I'm worried that they still might fix it. And with that, I'm going to stop hacking Stan's feed and let you have him back again.
Thank you to Dan McCrook, and welcome back, Stan McCoy. It looks like Dan was very happy with how things are, so I will take now the opportunity to ask you a few questions about Dan's interpretation, because it looks like he's very, very happy, and that is not positive for the creative industry, is it? So I was just wondering, since Marco Giorello from the Commission mentioned a few aspects that remain still valid despite Article 17, which, by the way, we don't know if it's going to survive the case at the court either, so there are many unknown elements still out there. What about the rules on the trusted flaggers? I mean, it seems to be, this should be applicable also for enforcement actions. I guess that MPA would candidate as a trusted flagger. How do you see these aspects? You also mentioned transparency rules and the rules on concerning the abuses of notices as well. So there might still be something good for Stan, even if Dan might not like it.
Yeah, indeed. I think Dan is Dan obviously has a particular cyber criminal perspective on all of this. I rarely agree with him. He happens to be right about the fact that the whole Article 6 interpretation was already the Commission's interpretation of pre-existing law. But on the trusted flagger point in particular, I think, of course, the availability of trusted flagger status is something that I think rights holders across the board can support, but it ought to be available to everyone who actually is a trusted flagger. We're a little concerned about some language that suggests it would only be available to representative bodies. Many rights holders look at the use of notice and action as an integrated part of a commercial release strategy over which they want to have direct control. If the timing of your notices and the volume of your notices is very important to you in connection with how you're protecting content in the context of a particular audiovisual release, for example, you don't necessarily want to give over those vitally important responsibilities to an outside organization, no matter how much you trust it. If you are yourself someone who has a track record of sending good notices, you shouldn't have to have a particular type of legal entity in order to qualify. So that would be the really critical point there. And I would say more broad on your broader point. Yeah, there are a lot of good and helpful things in the DSA that will help to advance overall rule of law in the online environment. So, the Dan McCrook assessment is a little bit ungenerous to the Commission and the good work it's doing here, but it can be improved in terms of the overall strength of the response to online cybercrime. And I think that's a critical consideration for the agency.
And Stan, what about your experience with the notifications as well? Because Eleonora mentioned this, and Dan McCrook as well, the issue of the URL, and that now the big commercial-wise scaled piracy, well, they maybe don't use URLs anymore. They are on different technologies. How would you recommend to address this issue? How should the notices be made also to not put the enforcement bodies in the end in a disgraceful position of not being able to pursue the notices?
Yeah, it just needs to be redrafted in a technology neutral way. I think it's really that simple. I mean, in just a few weeks ago, the Spanish National Police had a major operation to take down Mobdro, which was one of the world's biggest piracy applications, basically app-based piracy that you could access through your smartphone or through a connected TV device. That was a great action, but that's not an app-based technology. That's an app. That's not a URL-based technology. It's an app-based technology, and we've just got to be we've got to restate the standard in a way that's in a way that's reasonable but isn't tied to a particular technology.
Thank you, Stan, for this remark. I'm sure we'll get back to you also later on when the audience also will ask questions in the chat box, so keep an eye. In the meantime, since we have mentioned platforms, I would like to call on screen YouTube. We have with us Marco Pancini. He's Government Affairs and Public Policy Director for YouTube. And I think with your experience, you are certainly well placed to tell us the behind the stage experience from your point of view. Marco has a long-standing working experience with online platforms. He was appointed Director of Public Policy for YouTube in 2018. And prior to this role, he led Google's EU Commission and Council team in Brussels. And before Google, Marco was Head of Legal and Trust and Safety at Italian subsidiary of eBay until 2007, which was iBazaar, with the startupper iBazaar. So you've basically worked your entire life online. We are still with you online here today, so I'm sure you are very well placed to tell us about the experience that Google has had already with filtering and blocking of illegal content, and how you see from your perspective these new requirements that are coming, both from the Copyright Directive and from the DSA. The screen is yours, Marco.
Thank you very much, Maya, and thank you very much for this invitation from the Observatory for this very interesting event. And once again, congratulations to Stan for the presentation. It was very, very good and very clear. I don't have slides, so I will try to be as clear as possible. I would like to make two main points. The first point is actually will surprise you, but I wanted to congratulate the Commission for the very important work that was done in trying to square the circle between the DSA, which it's, as we know, it's a date and an updated version of the Commerce Directive, and other important pieces of legislation, like, for example, the Copyright Directive. I see these two pieces of legislation, as Eleonora said, as being able to live together, hopefully in a harmonic way. But especially I see some elements inside the DSA very important for us to clarify some of the points that, in my opinion, remain not totally clear from the Copyright Directive. I'm referring in particular to two new innovation introduced by the DSA. First one is the Good Samaritan clause, and the second one is the clarification about active and passive hosting. I think in both of the cases, so the Good Samaritan law is clause is this new article of the DSA, which says that platforms in performing content moderation on the platform and in removing content because they receive a notice, they are not they cannot become liable for mistake that they made in good faith. The second that I was referring to is the clarification that there should not be such a thing like active and passive hosting, but in looking at technology and how technology are interacting with content online, the DSA is setting a series of obligations that platforms has to take, and some of them were mentioned by Stan, like, for example, the risk assessment that are guiding platforms in the process of taking into consideration the different issues. So once again, I think these two principles, even if not directly interrelated with the Copyright Directive, are very important for us to look at some areas of the Copyright Directive where we didn't have further clarification from the Commission. The second point that I would like to make, on top of, once again, complimenting the Commission for the good job in coordinating these two initiatives, is still about the Copyright Directive implementation process. In particular, something that is very important is to make sure that in implementing the Copyright Directive, as Marco mentioned, that we keep in consideration that the final text is the result of a very complex negotiation happened across like 2 years of time with different phases and different very heated discussions. So here it's more a pledge. I think that we are really looking forward to have a factual and punctual implementation of the Copyright Directive that, for example, don't try to change some of the key elements of it, like, as was mentioned, the principle of proportionality, or as was mentioned, the principle of best effort, which has to be taken by the platform in interacting with right owners, in engaging in licensing agreements and negotiation, in removing content whenever we are receiving a notice. So these two elements are for us very important, and maybe this is a good reminder for us in thinking about how the DSA will be translated. We are seeing, for example, some member states translating the principle of best effort like all possible efforts, which is moving the balance that we've seen before. So that's something that still is for us, for example, a reason of concern. I cannot hear you, Maya. I cannot hear you, so I cannot answer to your question. You want me to try to reconnect? To talk? No, if I can go on. Sure, of course, of course, of course. Okay, one element that, for example, I didn't mention that for me quite relevant in the context of the DSA is the element of the notice, was touched by Stan in his presentation. I think the notice, as described in the DSA, is actually providing us very important guidance of, for example, what kind of notice would be expected, is expected from platforms also in the context of the Copyright Directive. One point that we made, and Marco knows this very well during the discussion and the negotiation, is that in order to be precise, in order to avoid that we are creating unintended consequences for our users and our creators, we need to have clear information about the content we need to take action on in case of copyright infringement on our platforms. So that's, for example, something that is absolutely key. The clarification that we are having through the DSA in terms of what the notice should look like are hopefully also very useful guidelines whenever there will be questions raising from the application of Article 17, a different implementation of when a correct notice was sent to platforms, and then when is triggered the obligation for platforms to put in place the mitigations. I still cannot hear you, but if you want me, I can go on. Just give me a sign.
Do you hear me now?
Yes, now I can hear you.
Okay, I'm sorry. You might have understood that we have had the problem here in the studio. Everything collapsed. So you got some bonus minutes. Marco, thank you very much for being sporty and understanding. You see, sign language in Italian is brilliant because it allows
Absolutely.
you, even without a microphone, to continue. So I understand that in the end you are not too unhappy with the DSA. I think it builds very much on the experience that you have built so far, and you're ready to do your part. That is the main message that I guess we can take. Of course, we will follow closely what will happen on the piracy initiatives that Marco Giorello just announced. So there might be something more out there, but I trust you're ready to play your part. I will call you in, but I need to catch a little bit up on the time, so I will not ask you further follow-up questions, and forgive me for that. But I need to move on and call on screen Stéphanie Martin. Stephanie is a legal advisor at the Society of Audiovisual Authors, SAA, a position she has held since 2019. Welcome, Stephanie. Stephanie has started her career as a legal and project officer at the French Center for Scientific Research and was then later seconded at the National Expert European Commission. So you have also an experience from the other side, which is also good to have. And before joining the collective management organization, Stephanie worked as manager of legal affairs at GS1, an international standards development organization. So we have invited you here to hear, of course, from the perspective of those who not produce the work, but who author the works that are protected content. And we have heard that the DSA introduces some rules for the traceability of business customers. Denmark Crook was very happy with how they were drafted, as you heard, Stephanie. So I'm now curious to hear what you think about know your business customer principle. Do you think that this can be a good solution to fight against copyright piracy? The screen is yours, Stephanie.
Thank you very much, Maya. I don't know if it has started because I can't see anything, but I guess it has. So thank you very much, Maya, for the invitation. It's a real pleasure to be part of the panel here today. Before I start, I would like to say a few words about the SAA for the viewers who do not know us yet. So the SAA is a European association, umbrella association, and we represent 33 collective management organizations that are based in 25 European countries, and our members manage the rights of over 160,000 film, TV, and multimedia European screenwriters and directors. So this is a lot of European audiovisual authors. So now, to get back to your question on the Know Your Business Customer obligation, to be very honest, we have mixed feelings about this obligation. On the one hand, we welcome it because we think it's an important tool to identify infringers and illegal content. And more specifically, we think it could help ensure that the private copying compensation is not circumvented online. So what does that mean? As some of you know, there is in most EU member states a private copying exception which allows individuals to make copies of works for personal uses, but provided that manufacturers and sellers of electronic devices and recording media pay a fair compensation to rights holders. And this compensation is very important for audiovisual authors because it is an important source of income for them. However, in practice, it turns out that some of those traders do not comply with this obligation when they sell their products online through online marketplaces. Therefore, we think that the Know Your Business Customer obligation can help identify such traders and verify that they do comply with the private copying compensation. But in order for this to work, we consider that online marketplaces should also refrain from providing their services to those traders. And in case they would still provide their services to those traders, then we think they should be held liable. On the other hand, although we support the Know Your Business Customer obligation, we also deplore that it only applies to online marketplaces. And we think it should be extended to all types of online intermediaries if we really want to tackle illegal content and repeat infringement in the digital environment. Now, on transparency, very briefly, we welcome transparency reporting for two reasons. First, transparency is obviously paramount to have visibility about infringements and thereby to better prevent illegal content. And we think that the current transparency and information requirements that are set out in the e-commerce directive should also be strengthened. Now, the second reason, since our members engage with in contractual negotiations with some of those online platforms, we think it would be very helpful to have detailed reporting that would give our members with some information about the exploitation of works. And let's say it's like killing two birds with one stone, meaning that with this detailed reporting that would help, in terms of enforcement, it would also help our members evaluate the rate for the remuneration of authors and thereby ensure that authors do receive a fair remuneration. Thank you very much for listening.
Stephanie, this was a new perspective, indeed, because we don't think about it when we go and buy in a real store a device. Of course, we are used to the little tax, let's say, for private copying, but then when it goes online, this is maybe not so intuitive. So I guess this is an interesting, let's say, a secondary effect of the Know Your Business customer, that if you allow me this medical terminology, so that is very, very interesting. Is there something in particular on the transparency rules that you mentioned that you think could be particularly helpful for the piracy aspect? You mentioned in particular calculate remuneration, which of course is another aspect that goes with. But when it comes to piracy issues, which of course are also relevant for get the proper remuneration of the works, do you see something good coming from the DSA that could impact? What's your view on that?
Well, yes, obviously, when we talk with our members, they do say to us that it's important for them to have transparency and reporting and to have detailed reporting. For them, it's paramount. Without it, it's obviously more difficult to evaluate what type of infringements are occurring and to be able to adjust and to react to those infringements. So for them, when we talk to them, they do say that those transparency rules are necessary. So we need to have them, obviously.
Mm-hmm. And what about these new initiatives that might come on piracy that we have heard earlier today? Of course, this comes as a new announcement, but even if it starts in the sports area, of course, it can inspire also creative industries. Would there be something that you would advocate for, something that you are missing in the current protection measures?
Well, to be really honest, for me, at my level, it's very difficult to answer. I think this is something that I would really need to speak about with our members, about these new initiatives in the sports sector, to see how we could relate this to our own sector in the creative industry. So to be really honest with you, for me, it's a bit difficult to provide an answer like this without consulting with them. But definitely,
I understand.
We are obviously looking at what's happening in other sectors, that's for sure.
Yeah, no, and of course things can be easily inspired as well. So
Exactly.
I guess that is good. Well, thank you for now, Stephanie. Take a look also at the chat box. I see that there are already quite many questions for Stan McCoy. So feel free, Stan, also to answer directly in the chat box to the questions that are for you. In the meantime, I would like to call up our last speaker, who is Maria Michalis. She is representing the European Alliance of Listeners and Viewers Association, Euralva. Welcome, Maria. Maria is also a associate professor in communication policy at the University of Westminster and has been for over 20 years now researching media policy and regulation, mostly in Britain and Europe, published widely on these issues. So on top of representing the viewers, you are also an expert in the field. So thanks for being with us. And I'm very happy that you are here because you help us bring in another another view, which is so far not been touched upon, because we have talked a lot about the importance of blocking the spread of copyright protected rules, but we know that there are also many legitimate uses of copyright protected content. So do you see any risks for the users' rights with these rules, the copyright directive and the new ones coming from the DSA? How will this work? The screen is yours.
Thank you. Thank you, Maya, and thank you for the invitation to participate in this webinar. I'm delighted to be here. I'll briefly mention a couple of positive aspects contained in the DSA, and then I'll move on to risks and concerns. So what is positive? I'll single out two elements. One, the DSA makes more references to fundamental rights compared to other pieces of EU legislation. This is welcome. Two, the DSA has the potential to improve significantly the transparency and accountability of decisions made by internet intermediaries to remove or otherwise restrict access to content. These are the main positive aspects from the perspective of users. However, welcome though these provisions are, they lack detail. They are incredibly vague at this stage. And a lot will depend on how these provisions are implemented nationally and on any guidance from the EU institutions, mainly the Commission and the Court of Justice. So going forward, it is imperative that the transparency and accountability obligations, for instance, are fulfilled and explained in plain language, and this will strengthen trust in the legal framework. Now turning to risks. The risks concern primarily the impact of the proposed measures upon fundamental rights, the freedom of expression in particular, but also upon the rights to privacy, data protection, and so on. I'm sure this isn't news to this audience. This is not a new debate. It's as old as copyright itself. More recently, we had discussions around the copyright directive, also the Polish legal challenge currently pending in front of the Court of Justice, requesting the annulment of parts of Article 17 of the Copyright Directive, illustrates clearly that this remains an issue. It seems that the policy debate is moving from the liability of platforms to the responsibility of platforms to make decisions about online content. And in a way, we are witnessing the privatization of regulation, growing calls for platforms, that is private companies, to police essentially online content, and this is a concern. Now, specifically with regard to copyright, the main and most obvious risk is that there will be a significant amount of overblocking because technology is not good at making judgments and evaluating context, both of which are crucial and necessary to distinguish between copyright infringement and legal content. So, for instance, if we think about user rights safeguards, such as the copyright exemption for caricature, parody, and pastiche, technological solutions aren't able to make these calls. There is already evidence of overblocking, and such instances are likely to increase with the implementation of the Copyright Directive and the DSA. The platforms are put in a difficult position because they face the risk of direct liability. So the impetus will be on the removal of content to avoid any liability risk. To this, one should add opportunities for abuse of the system, including fraudulent claims and so on. The safeguards for overblocking are insufficiently defined. The DSA has an indirect reference to a fundamental rights impact assessment, and this is welcome, but there is no guidance as to how this can be done in practice and how to address potential conflicts. So to conclude, the risks upon fundamental rights from copyright enforcement are real. The DSA contains some welcome provisions around transparency and accountability obligations and references to fundamental rights, but we need to adopt these provisions and provide guidance and practical detail to make them a reality. Thank you.
Thank you, Maria, for having shared these concerns. Indeed, this is an old debate, but machines, they make things more difficult because they are certainly not able to make all the sophisticated distinctions that a human mind can do. Is there any way, because this is of course a problem when you have automated interventions, and but now we have also initiatives on AI coming on the table. Do you see a further interaction? This is a little bit going out of the scope of the seminar today, but speaking of fundamental rights, this is of course also at the core of all the discussions that concern the use of automated means of intervening here. How do you see the big picture?
First of all, I think it would be good if the legal framework can provide incentives for platforms and technology companies to innovate in this area, so they don't all use the same filtering solutions, technological measures, and so on. So I think, platforms and technology companies can be more innovative, and this can be also a competitive advantage. So perhaps the legislators, policymakers can think of ways that can incentivize platforms and the technology companies to do precisely that.
And another thing I was now thinking, we have talked about procedures and we have considered now the problems of those who do the notices, but what about the participation of viewers in such proceedings? Do you see, it's not foreseen at the moment, but I'm just imagining a way of bringing on board the concerns that you raise for the legitimate users. So have you made any reflection on how the viewers could be more involved in these cases that will inevitably happen?
Well, in such cases, I mean, there are already various organizations and actions from users groups in general to try and have a voice in these debates and see how the implementation of this, the adoption and then implementation of these measures will go. And there are also, I mean, and we are keeping an eye on all these debates, recent developments regarding online sports and so on. So, I mean, that's basically it.
Yeah, no, indeed. We are all in the making, so it's also not easy to imagine how the discussion will be, but I guess you will follow the discussion closely, and when there is space for bringing on board a human rights perspective, it's good that we have watchdogs there. So thank you for fulfilling this role. I would like to take a look in the chat box, and I have actually a question for you, Maria. What is the view from Juralva to ensure viewers that are protected from... No, sorry, I'm reading it wrong. What is the view from Juralva in view of ensuring viewers protected from illegal and harmful content? How is pushing the overblocking serving to protect users where viewers are better served with more rather than less obligations? So basically... how to do the balance from protecting the viewers from illegal and harmful content with the risk of the overblocking. That's another balance. Microphone.
This is not just about copyright, but it's a broader question about harmful content, which is, of course, a concern. I would like to go back to one thing that I mentioned earlier. It's about who makes these decisions. Very often the discussion is about regulating platforms, but at the end of the day, it's about regulating users, you and me. And these discussions need to take place in parliaments so that we have proper democratic accountability and a democratic debate about what is harmful content and what are the best means to deal with these issues, which are real issues. And there are currently many debates also here in Britain with the online safety bill underway and so on. But as I said, many of these debates are debates for parliaments. And that's the first thing that we need to make sure. It's about the whole society, how we deal with them.
Absolutely, and this is also, as you say, another chapter of the DSA, which concerns content moderation, harmful content. So it's indeed another side, but important to consider when we talk about the viewers' rights in this context. I continue to, so thanks a lot for this, Maria. I see there are some other questions here, some for Stan McCoy. There is one in particular that maybe I would like to ask. So if my colleagues can bring all speakers on board on screen, that makes it easier. To Stan McCoy, there is a question on emerging pirating practices. So it's maybe a question to Dan more than to Stan. So how future-proof would you say the DSA is in terms of emerging pirating practices, and how can policy making at the EU level be more responsive in the future? What do you see in your crystal ball?
Well, I think the one thing I can say with certainty is 5 years from now there will be some new form of piracy that I can't even imagine right now. So the technology neutral is very important, and we've talked about a couple of examples of that already. There's that URL requirement. There's making sure trusted flagger is broadly available. There's making sure that KYBC has a broad scope, so it's not limited to it's not limited to one type of platform where there's a perception of a problem now, but it's available to broader types of platforms. And another, aspect, I think, that of technology neutrality, I would respectfully take issue with Marco Pancini on this one, is on the active-passive distinction. There are a lot of people arguing that that's an outdated distinction and should be thrown away, but a huge part of the internet still runs on passive hosting providers, web hosting providers, CDN providers. Those are the people that this active-passive distinction is meant to protect. So I think it's a real myth that active-passive is somehow no longer fit for purpose. I would call that one of the more durable and technology neutral elements of the existing legal apparatus that frankly ought to be maintained and carried forward.
Thank you, Stan. I'm sure also Eleonora will come back to that in her final impressions, because she mentioned the court, the case law of Court of Justice. I don't know, Marco, if you would like to, how do you feel? I mean, you're certainly active. I would say now that is certainly a role of YouTube that has been stated in many of these judgments. Do you really think that now this is wiped off?
I don't think it's a wipe. It's not actually up to me to decide if it is or it is not. I'm just registering what is in the DSA. I'm registering also what's the direction of travel of the legislation in the field of online platforms. The definition that we are seeing, video online platforms, large platforms, you can call them in different ways, but are not making reference anymore to the active passive hosting, which I think is not. I don't think it's also the good filter to look at the problems that we have in front of us. I think what the Commission is trying to do with the DSA, and what it did also in the context of the Copyright Directive, is to come with some rules that practically and fit for purpose give clarity on the role and responsibility of the different players in the sector. So not give like general distinction, then will be one day maybe used in a litigation and can be helpful for a judge to decide a case. Here, the Commission is really trying to come with a framework under which all the activities and the great collaboration that we have in place between platforms and right owners can go to the next level and become even more successful. So I like this approach, which is going in the direction to support and make agreements easier and reduce the level of conflict.
I'm sure Marco Giorello will comment on this. I have another question to Stan. You're quite popular in the chat box here. They are saying that, it's quite interesting, how are the rights of the internet providers and regular viewers protected against the exaggeration of big movie companies and organizations like MPA? Do you feel that you fit into this? What could this exaggeration refer to? We have talked about trusted flaggers, but
Yeah, I guess I would have to respectfully disagree with the questioner. I don't think the rights holder concerns, I won't limit it to the MPA concerns, are exaggerated. And remember, we're talking about broader categories of illegal content here, as Maria pointed out earlier. So we're not necessarily, when we're talking about illegal content in the DSA, we're not necessarily talking about only infringing content, but the questioner might be referring to the rare cases of faulty notices that are sent in. I think it's exceedingly rare that those notices come from any entity that the industry would consider a trusted flagger. I think it is there have been some anecdotal cases of people cooking up notices for reasons having nothing really to do with copyright, and there are redress mechanisms to deal with improper notices, as there should be, but those are vanishingly rare cases in comparison to the overall success of notice and action in dealing with an avalanche of illegal content on the internet.
Yeah, no, and that's absolutely important to underline. We are focusing here on the big commercial scale piracy actions, and certainly not on the small infringements of single users. There is a question that maybe Marco Giorello might point to when he wraps up at the end about the definition of trusted flaggers, because I think you, Stan, mentioned something about commercial industry representatives falling out of the scope of the definition of trusted flaggers, and there's a question on this, but I will leave Marco Giorello think about this while I take, there are some questions that maybe you can also directly reply to in the chat box. Stephanie, there is one for you about database to identify the sellers. Maybe you can address that directly in the chat if you are aware of any such database with the link. And
I'm actually answering.
Very good. Then you read my mind. And with this, I would welcome Eleonora to give us her impressions. I mean, you've been in listening mode for quite a while now. We have heard many things, very different perspectives from various areas, moments of the value chain. So what are your main takeaways in 3 minutes?
I would like to tackle 3 points and give, an umbrella comment. And the umbrella comment is that I think it is clear from the presentations that we have heard today that there is a close relationship between copyright and DSA, and that there are both risks and opportunities underlying the adoption of this new instrument. So indeed, it is a broader ecosystem, and it is important that one's own specialism does not lead to one-sided assessments. We need to work in a system where there are so many contrasting interests and rights that are at issue and needs to be fairly balanced against each other. So this is my general comment. Then there are 3 points that I would like to briefly touch upon. One is the point that you've made and that follows from the discussion that we've just heard about safe harbor availability. I think that it is quite telling that after over 20 years since the adoption of the e-commerce directive, we still don't know when the safe harbors are actually available and for what. Here I would like to point out participants to read the opinion of the Advocate General on YouTube. Indeed, touches upon this point. He refers to a wealth of literature. So indeed, one might wonder whether what has happened so far in these over 2 decades of application has led to greater clarity as to when the safe harbor is actually invocable with success. The second point, which follows from a question that has been raised in the chat, concerns user rights and whether the DSA has safeguards in place for the doing of freedom of expression related activities that engage the use of third-party copyright content. Of course, this is not something that is part of the DSA. It is in the DSM directive. The directive mandates upon member states to introduce or maintain exceptions and limitations that are freedom of expression oriented, quotation, parody are key examples. And as regards memes and GIFs, there is a long-standing debate. I am not persuaded that they have become illegal, because probably they've never been legal. They are, borderline between infringement and not. Of course, no one would enforce copyrights in these forms of user creativity, but the EU copyright system is rather inflexible also from this point of view. And the final point builds upon something that Marco mentioned, Marco Pancini, regarding the question of translations of various instruments, and he made a reference to the DSM directive. And now, the transposition phase in which these linguistic issues have started emerging again. Of course, for the DSA, this problem will not be there because it will be a regulation and not a directive. So you will really bypass the national transposition phase. But in relation to the directive, I think it is important to point out that once this directive has been adopted, then it will be for the member states to ensure a faithful transposition, because otherwise the risk is going against this idea of creating a single market, a digital single market, in which uniformity allows for the removal of barriers. So if there is a linguistic problem, I think it is something that has to do with the various language versions of the directive, but this is not something that necessarily member states will need to be concerned with now in the transposition phase. So that will be my 3 key points. Thanks for having me.
Thank you, Eleonora. Indeed, the beauty of Europe is diversity, also in languages, but can be tricky. So we'll see how that will be dealt with in practice. And indeed, the DSA is a regulation, so then there is no big room for fantasy among the member states. And so there might be a reason why this was chosen instead of a directive. Speaking about the choice, then I would like to turn back to the European Commission and Marco Giorello, who has also been in listening mode, and many things have been said. If we can have Marco on the screen, I would like to ask him what his impressions are. Is there something you learned today, something useful that you will take home? No, you are already home, but I mean take back to work when continuing dealing with these files. Marco.
Yes, of course it was very, very useful, and I think all the points that have been made are definitely food for thought for the Commission. Now, a point I would like to come back to is the horizontal nature of the DSA, and probably is not the first nor the last time that you will hear the Commission hammering on this. I think that it is understandable that from the perspective of copyright stakeholders, you're trying the right holders to basically try to have, let's say, as much as possible an instrument which takes into account the specificity of the copyright sector. But I think it's also important to keep in mind, again, that here we are not only dealing with copyright, we are dealing with a lot of different situations, and that going, very far away in terms of intrusiveness, so to say, into the functioning of the internet economy, like, for example, inserting stay down obligations of the type that we have in Article 17, would be potentially, first of all, a minefield in terms of negotiation, but may also not be proportionate when we are dealing with illegal content or potentially illegal content in situations others than copyright. So let's say that my word of conclusion is a little bit, again, to go back from where I started, is really a word of caution in trying, to avoid as much as possible the DSA to become another copyright battlefield, because I think that in the end it would be a lose-lose situation, both for the DSA and for the copyright stakeholders. Of course, we are at the beginning of a legislative process, and we are definitely, as I say, listening very careful to the concerns. Of course, I mean, as in any legislative process, there will unavoidably adjustment, changes, proposals which come from the Parliament and the Council, and that the Commission will take into account. So I'm not, of course, closing the door to any discussion to the contrary, but it's really a word of caution. And again, Article 17, I think, has a self-standing, let's say, balance, which, we may like or not fully or in part, but that I think, should continue walking on its own legs. And on the other hand, piracy, as I said at the beginning, I mean, we're not yet at a point where the Commission is ready, to announce a specific follow-up to the Parliament report, but definitely we will respond to the Parliament. This is very clear, and further work on piracy will be done. So, there may be better channels than the DSA to address copyright-specific situations, and this is let's say, my concluding word, while, of course, being very open to continue the discussion for everything which relates to the DSA itself. Thanks a lot.
Thanks a lot, Marco. I think it's important to know that indeed the work is continuing. We will also see what the court will decide, because that could be another scenario. If Article 17 disappears from the stage, well, then maybe we have another problem. Yeah, but that is a bit too early to discuss before then. So we will... I saw there were some questions about when we will have the guidelines, but I assume that they are about to come, so we will wait for them to be published, and that will be an interesting reading, I think, for us all. So with this, I think we have plenty of food for thought. I don't think I can keep it. I see just a question to you. Let me see if we manage. Well, this introduces a bit another topic. It's on trademarks. If you want to maybe look at it in the chat box, you might do so. But we have some technical issues here, so I don't want to keep it going too long. But I would like to thank everyone. So if my colleagues can help me have everyone on screen, I would like to thank our contributors from today warmly. We have had Eleonora Rosati from Stockholm University, Marco Giorello, European Commission, Stan McCoy, Motion Picture Association, MPA, Marco Pancini, YouTube Google, Stephanie Martin, Society of Audiovisual Authors, SAA, and Maria Michalis from European Alliance of Listeners and Viewers Associations, EURALVA, and then our audience. Thanks a lot also for the active participation in the chat box. And I can only tell you that we will be back in 5 weeks for another webinar, which will be our last one in the series, and we will talk about DSA and the fight against disinformation this time, which is also an equally interesting topic. The Commission has just come out with guidelines on this, so there is really a lot to look at. So see you in 5 weeks on the 1st of July at 4 p.m. Stay safe and goodbye. Thanks a lot for following.